Whoops, LinkedIn says you're not approved for LinkedIn Lives. It's only available for a limited group of members. Okay. Okay, whatever. That's fine. Remove that one. So we're going to remove LinkedIn. Save changes. That's fine. I can actually change it and add it to another group, though. So I don't have to share it to my page anymore. Perfect. Save changes, and we should be live, man. So let's check and make sure it's on my page, just to make sure. And we are live. Perfect. So Dan, we're going to talk a little bit about estate planning today. So let me do a brief introduction of what we're going to talk about, who you are, and things like that. So Dan Schnurbusch is an estate planning attorney in the state of Missouri. I'm going to throughout here, I'm going to put some questions on the screen. I'm going to put his information on the screen. So if you have any questions about wills or estate planning, trust, things like that, give him a call. But I wanted to hop on here and ask him a bunch of questions about estate planning, because I think he will be it'll really help a lot of people, especially nowadays with COVID going on. Everyone needs a will, and we're going to talk about that in a second. But before we do that, though, Dan, tell us about your practice a little bit and why you got into estate planning.
Sure. So as you say, I'm an estate planning attorney, and I work out of St. Charles, Missouri. I also service clients in the St. Louis area. But I got into estate planning in kind of an interesting way. After law school, I went to a mid-sized firm in downtown St. Louis. My dad, Kevin Schnurbusch, was one of the principals of the firm. They started it in 2000. They're trial attorneys. He was a wonderful trial attorney. They do a lot of litigation work, and I got a lot of wonderful experience in the courtroom, learning how to argue motions and take depositions and things like that. But the trouble was that my dad was sick, and I wanted to work with him as much as I could before he was gone. And that didn't exactly work out the way I had planned. He got pretty sick and actually passed away of cancer about 2 years ago. And when that happened, it kind of caused me to reevaluate, where I was going with my life and what I wanted to do. And perhaps coincidentally, he actually, is an attorney. He's an educated man. He was a trial lawyer. He knew what he was doing, but he passed away without a will. He had no estate plan of really any kind. And that led to, some weird circumstances for me and my mother and my sister and I, just kind of trying to piece together the estate, finding all the accounts and the assets and how they were titled, and calling the companies and going through all this hassle to kind of tie everything up. Fortunately, he had had the wherewithal to name my mother as beneficiary on a lot of different accounts, which helped. But even still, it was a struggle, and we were doing it by ourselves. I was an attorney. I can only imagine what that process is like for people who don't have that kind of background. But because of that, I kind of realized that if I can help people not have to deal with that. I mean, losing a loved one is hard enough already, without having to deal with all this stuff. And, it occurred to me that if I can help people get through this process, if I can help them avoid ever having to do some of the things that we had to do by having a good plan in place, and help them take those small steps that they could take to really move the needle on that, then that was what I was going to do. And so, I decided to start my estate planning practice, and that's what I've been doing ever since.
So I want to talk a little bit more about you having to deal, you and your mom having to deal whenever your dad passed away. I guess, what kind of strain did that put on you and your family? I know you kind of talked about that, but I mean, you didn't really go into much detail. I think you sort of glossed over a little bit, because I think you're making it sound easier than what it probably was.
Well, it was a process. So, we divvied up responsibility. I was working with certain companies and on the phone, and my mom was working with other companies and calling them and sending them documents and doing all this work. Fortunately, we did not have to probate anything because most of the assets passed through other beneficiary designations. And fortunately, my mom was there, and me and my sister are competent adults, and there weren't any issues with that passing that way. But it was a process, and it took a lot of time. I think it took almost a year to get everything organized and up to speed and put together. And my poor mom, I mean, she's kind of, in a haze trying to, get over this, not get over, but kind of work through this, tremendous loss at the same time. And I was kind of in caregiver mode trying to help her, organize her life, because my dad, he did a lot of the finances. And maybe that's just, kind of the way things were in that kind of more traditional household, that, she kind of took care of us, and my dad took care of the finances, and she was lost. And so I really had to step in and help her move through that and kind of organize that process. And it was a lot of work. We're blessed to the extent that we didn't actually have to go to court on top of that. But for many families, that's not true. They've got assets that need to go through the probate system and go through the court process and call lawyers and bring people in for that too. So yeah, it could have been worse, but we got through it.
I just want to let everybody know that if you do have a question, there's a scroll going along the bottom. So you could text us if you want, 314-668-2001, or you should be able to post your questions in the comments. And this is a new technology that we're using, StreamYard, and we should be able to put the questions on the screen. So if you have any questions, just post them. And I do see that we've got some in Facebook already. I'll see if they actually pop up on my screen. But I do want to make sure that we're all on the same page, because I'm not sure everyone really understands what it means to even have an estate plan. And before I was a lawyer, I really didn't understand all of it either. So what is an estate plan?
Yeah, I mean, you're absolutely right. A lot of people, even very educated people, don't fully understand what it means. I was talking to a guy who works with multi-million-dollar companies today, advising them on logistics issues. And he asked me the same thing. He's like, I don't really know what that means when you say that you do estate planning. So what that means to me is that we're, I'm working with individuals and families to really plan for, two of the biggest things in your life. You're planning for, everyone that you love and everything that you have. You're trying to identify the people that are dependent on you and that you care about in your life. You're trying to identify your assets. You're trying to identify your goals, your what you want to happen to your family. You're trying to identify your fears, what you're afraid of happening if something isn't properly planned for, and then taking all of that and then working to develop, legal entities, documents, and a plan that, meshes all this together. Whatever the law says, whatever the contracts say, working with that to create a plan that molds to, your unique circumstances. Everybody's family is a little bit different. And so it helps to really pull all that together and get a good picture of it, and then come up with a plan that's going to be a combination of documents and designations and working with friends and family members and trusted people to kind of put together an idea of, if this happens, here's where I want to take over. Here's how I want that process to go. If something happens to me and my spouse, this is who I want to take care of my kids. Answering those kinds of questions, so that if something happens, we've got a rule book to go by, rather than having to go to court and ask a judge to tell us what to do.
So Dan, we have questions that are coming in on Facebook and then also on my screen. So I'm gonna try to put the first one here on the screen. It's from Wendy. It says, "This is such a coincidence. My father-in-law recently passed, and my husband is driving back and forth to help his mom. What would you recommend for a family that had no direction through a will?"
Had no direction through a will. Well, I'm a little unsure. It depends. If there's really no estate plan at all, there's no will, there's no trust. I think the first step is really trying to get a handle on what assets there are. How is the house titled? How are the 401k and the IRA? What's happening with those? Do those have beneficiaries designated on them? If so, you might just need to contact the company or the company that administers or manages those plans. They may have things that they want to get from you, documents they want to get from you, such as a certificate of death or something like that, to be able to release the funds to whoever they're entitled. But really, it's going to be a matter of identifying all the different pieces that are in play and figuring out what's going to happen to them. So if you've got a house that is jointly titled with the other spouse, by operation of law, that'll pass to the other spouse. If you've got 401ks or insurance policies that name certain people, those assets are going to pass to those people, and there's not much we can do about that. If there's no other plan, there's no other will or trust or documents like that. That's how those assets are going to flow. If there are things that are in the person's individual name, those assets might need to be probated. So you want to talk to, it's a very good idea, I think, to talk to an attorney and get a good clear picture of what the assets are, how they're titled, who the beneficiaries are, and what has already happened to those assets, perhaps by operation of law. And then simply what needs to be done to actually, in practice, bring that out and make make those assets subject to your control. That's kind of would be the next step in kind of working through that process.
So Dan, you and your mom were in the same situation whenever this happened. So how were you able to track down all the bank accounts and like if there's any investments?
Yeah.
I mean, I don't know if he maybe had like a E-Trade account or something like that. I mean, how do you know you have everything?
Yeah, I mean, it was a process, and fortunately, my mom was joint owner on most of these things, and she, on a fairly regular basis, interacted with a lot of these accounts. But it is, and there very well may still be accounts out there that he hasn't thought about in a while. But fortunately, he had been at the same employer for a long time, so we were able to say, all right, all of his work sponsored employment or his work sponsored policies are coming through here. His work sponsored plans are coming through here. We know he rolled over his old plans into here, so we don't need to worry about looking at his old employers. My mom fortunately was aware of what real estate they owned and things like that. So that piece of it didn't take a lot of digging. But it's one of the reasons that it's so important to work through this process in advance, to keep track of, here's my accounts, here's my property, here's where it's located, here's in addition to just the legal documentation of writing a will or a trust or a power of attorney or whatever, having some kind of centralized place to keep track of the stuff that you own. And another thing that I work with people on as well is consolidating, because once you've reached a certain age, you might have several different accounts. I know I have several different checking accounts and savings accounts and things that I've just opened up over the years because I like the interest rate better on this one, so I'm going to switch my checking over to here or whoever. And I just never close out the old account. But it's an important piece of it to try and, when you're thinking through this process, to gradually keep stock of what you got and call back, get rid of things that you're not using anymore, accounts that are just that you don't want to have to deal with those institutions anymore, or you don't want your beneficiaries to have to go deal with these institutions when you pass away. It's a really good time to kind of take stock and get rid of things that are not helpful, and just be aware of what you have so that it's easier on your beneficiaries, easier on any trustee, easier on your executor, so that process can go as smoothly as possible.
So Dan, we've been talking basically, like, one of my questions actually, what happens if people don't do any kind of estate planning? And that's kind of what you've been talking about anyways. And you mentioned that things go to probate. I don't think people know what that means either. So what does it mean that a case goes to probate, or that a will goes to probate? Sure.
So any assets that are in that do not automatically pass by virtue of a contract, or by virtue of the fact that that you don't own them. For example, if they're owned by a trust, and they're owned in your individual name, or they will need to be go through the probate system. And what the probate system is essentially, it's just a portion of the district court system, or the lower court system in every state, they do every day is process people who die without a will or who die with a will, and there are assets subject to probate. So a probate asset is one that doesn't pass by trust or by joint titling or by contract. So essentially, you have a title to this piece of property, and you, as the beneficiary, can't just take that property. Like if I inherit a house, I can't just go and sell that house until that house is in my name. And the way that house goes into my name is through title being changed. And if we don't have a contract changing that title, if we don't have a beneficiary deed changing that title, if we don't have a trust changing that title, the only other way to change that title is to go to court and ask a judge to say, all right, here's what the will says, here's what the intestacy statutes say, or here's what the heir law, the laws of heirs say. You now own it. Here's the order. That's the only way to do it. So you have to go through a court process. Now, most of the time, a lot of families don't want to deal with that because in order to go through the probate process, you've got to publish the will in court. You got to file it with the court, which is a public thing. Everybody can go on CaseNet right now and search probate cases, and you can look at people's wills. It's a public process. As soon as you file, you've got a 6-month window where you've got to notify creditors so they can come in and say, hey, I had a mortgage on your house, or you owe me a credit card debt. I'm gonna try and collect against the estate. It opens up the possibility of people who said, hey, this wasn't supposed to go to Joe. Dad said it was supposed to go to me, so I'm going to try and challenge it. So a lot of people try to avoid the probate system entirely. Unfortunately, with a little bit of planning, it's not that hard to do. So we're going back to those things I talked about before. So contracts, joint titling, beneficiary designations, transfer on death designations, trusts, those sorts of tools can completely avoid the probate system. You don't have to go to court, and assets can pass through other means.
I love that you keep bringing up other devices other than just a will, because I think most people just think of estate planning as just a will, and it is so much more. Something you and I had talked about yesterday is, people after they have a kid, they think, oh my gosh, I should have a will. So when do you think people should really start thinking about the whole idea of putting together an estate plan?
So let me answer this with a story, I guess. Literally 2 months ago, I got a phone call from a very good friend of mine who's also a client, and his name's Kevin. He is in real estate. He's an investor, and I'd help him with some real estate things. And he calls me and he says, my sister died. She was in her 30s. She had 2 kids. And I said, what do you mean your sister died? She's like 35. And he said, well, a couple of weeks ago, she went to the hospital. She wasn't feeling well. It was a Friday, and they kept her over the weekend. They ran some tests, and as it turned out, she had advanced stage cancer. I think it was pancreas. I can't remember exactly what kind of cancer it was, but she had cancer, and they gave her some medication. They sent her home. They had a plan. She came back the next weekend feeling worse. And by the end of that weekend, she actually passed away. And within the space of a week, she went from feeling fairly normal to being gone. And she was in her 30s, and she left behind 2 kids who now Kevin is taking care of. And they're going through the court process of trying to get all that organized because she didn't have any documents yet. So and I don't mean to scare people with that, but I just want to say that the short answer is that you never know what could happen. Tragedy can strike, and it's good to be ready for that no matter what happens, especially if you have kids, minor kids that need to be taken care of. She didn't have the father was no longer in the picture, and so it was just her. So now they had to have somebody else take over her kids. So the short answer is that it's virtually never too early. I mean, there are even things you can do for college age kids. Now, it's maybe not the biggest deal in the world. I mean, you can have like powers of attorney for medical decisions and for financial decisions for kids if they get sick when they're in college, and or for accessing educational records or medical records if they get sick and can't take care of themselves. but really when people start to really depend on you, I think is the biggest time that you need to start really thinking seriously about it. But really anybody can benefit from it at really any time, even just for basic incapacity planning reasons.
I didn't even think about like a college student, like them having something in case something seriously happens to them where their parents can help them with their finances or their health decisions and all that.
Yeah, I mean, it lets your parents can go to your bank and go to your doctor and say, look, I'm the authorized agent. You're allowed to talk to me. And when you execute a medical power of attorney, for example, under Missouri law, you can actually have those put into your medical records. So your doctors, every time they pull up your chart, they'll see your power of attorney and who's designated as your medical agent. And so they always know who is able to talk with you and make decisions for you and help with that process. So can benefit even young people.
Incredible. So, and it's just tragic about her, but Jim had a question, and I don't know if you caught this. What should parents of young kids, I think you sort of cover this, but what should parents of young kids be thinking about when considering estate options?
Sure. So there are several different options, but we can think about it in terms of what happens if you don't do anything, and then kind of what your more advanced planning options are. So the default is, what a lot of people do is they'll say, oh, I'm going to name my wife as the primary on my IRA or my 401k or my life insurance policy, and I'm going to name my kids who are 4 and 7. I'm going to name them as the contingent beneficiaries. So if my wife is gone, then they will inherit. And while this arrangement, remember, this is a contract. So this is going to entitle those kids to the assets, and that's going to avoid probate. You're not going to have to go to probate to move those assets to those kids. But here's the problem: when they're a minor, they're not allowed to receive those assets without being under the protection of a conservator. So you're still going to have to go to court anyway if you don't do any planning for this type of thing, where you're going to have to go to court, request the court appoint a conservator, or a guardian as well. And depends on what state you're in. Missouri has conservators and guardians. Guardians are over the physical person. Conservators are over the finances. So you'll have to have a conservator appointed to manage that child's assets. And that will last until age 18 or whenever the conservatorship needs to terminate, depending on the circumstances of the kid. So that's what happens if you do nothing. A couple other ways to do it: you can designate the children, or designate a custodian for your children. If you want to avoid needing to appoint a conservator, you can say, I'm going to leave these assets to Jane Smith as custodian for my 2 children or my child. And what that will do is impose the transfers to minors law rules on that custodian. So they have to only use the money for the benefit of the child. And that's good. It gives the child some rights. It gives them some protection. They don't have to go to court. But the only problem with the custodianship is that they automatically terminate at age 18 or 21, depending on the circumstances and depending on state law. And a lot of people, suppose you leave a decent sized insurance policy or a retirement account. I know I would not have done smart things with, say, $500,000 or $1 million life insurance policy when I was 18 or 21 or 25 for that matter. So it is an option, and it's better than doing nothing. But the best option, in my opinion, is to set up some kind of trust, usually a revocable trust during life. You can set up testamentary trusts that live inside of a will, but they need to be probated. So my thinking on that oftentimes is, well, if you're going to have to probate to create the trust, and you're going to do a trust anyway, why not create a revocable trust? Let somebody take over the handle on that bucket when they pass away. We've got this bucket, we're filling it with assets. Let somebody else take over that. The child is entitled to assets under the trust, and somebody else is allowed to manage those assets for them. Maybe you designate one person as a guardian because they're a very loving relative. Maybe they're not the greatest with money. Maybe you designate a different relative who is good with money, or your financial advisor, or somebody else to serve as a financial trustee to oversee the child's money and distribute it to the guardian on an as-needed basis. But it can go even further than that. I mean, there are ways to own property that are simply better than owning them outright. And if you can set your kids up with, say they've got a discretionary spendthrift trust where once they reach a certain age, they can be the investment trustee. Maybe they manage all the assets, but they need the input of a third party to pull them out. And they become completely sheltered from creditors and predators and divorcing spouses. So there are a lot of things you can do to really look after children. But those are the three big ways of dealing with minor children is, what happens if you don't do anything? You've got the conservatorship. You could do a custodianship, but then it terminates early, or you can set up a trust. And I think those are a really powerful tool in a lot of different ways, especially for minor children.
Great answer. So let's get to the next one. You're streaming live to a bunch of people that mostly non-lawyers. I'd say more than half of them probably don't have a will. A lot of them, probably have TOD set up. They probably got POD set up, and they have a variety of other devices that they probably set up. And they probably think, "Oh, I'm fine, no big deal." Why do you think people might want to consider, though, working with an estate planning lawyer?
I mean, it depends. TODs and beneficiary designations and so on, those can work. And in some cases, that might be all your family needs. But it tends to be the case that most of the time there's at least one or more reasons for maybe doing something a little bit different or setting it up a little bit more, something a little more sophisticated. If you have minor beneficiaries who need specialized care, if you have property outside the state, if your kids are dispersed throughout the country, or maybe one of them is irresponsible or not so good with money, or maybe you have one with special needs, or there are so many different things that can trigger the ideas, some of the advantages of doing something a little more sophisticated, that a lot of times it may not jump immediately to mind if you haven't talked to somebody who they do this every day and this is their bread and butter. So part of it is in addition, doing things with a TOD or transfer or beneficiary designations and so on, those can work well if people pass away in the order that you expect them to. But if they don't, if you designate, a spouse or one of your kids and you predecease or they predecease you, things can get a little bit screwed up. Maybe they end up passing to somebody that you weren't expecting, or you lose the beneficiary designation entirely, and then it ends up in your probate estate. Whereas if you had, set up a trust, for example, that entity can't pass away. It's always there, and it's always there to receive assets. In addition to some of the more advanced benefits of using alternative estate planning vehicles, such as a trust, where you can, gain the benefits of asset protection. As I mentioned, where if you're inheriting assets in a asset protected trust, those can't be collected if you get in a bad accident. You're a personal injury lawyer. You know how this works. If you get in a bad accident and there's not enough insurance money, it can be good to have, some of your money and your inheritance tied up in a vehicle that can't be collected by anybody else. I mean, the most common is in the divorce context. So, if you inherit your money from your parents and you commingle it into a marital bank account with your spouse and treat it as if it's your marital property, and then you decide to get divorced, that property is subject to equitable division under Missouri's family laws. Whereas if that had been kept in a trust and segregated away from your other marital assets, you might be able to protect that, and your divorcing spouse might not be able to take those assets. So there are reasons to go beyond that. It just takes a little more advanced planning. It's a little bit more expensive, but it's not crazy. So these sorts of things you can do really kick the planning opportunities up to the next level. It's not for everybody. I mean, some people aren't interested in this stuff, but for those that are, there are some really powerful tools out there that are better, that are just better than doing it this way, and that can more accurately reflect your wishes and give you some of the advanced benefits of a more advanced estate plan.
I love it. All right, I'm going to get to my next question, which is probably my favorite question. Is LegalZoom a good idea?
Depends what you want to do, and depends who you are. LegalZoom works for certain families, similar to the beneficiary designation and TOD issue. That if you've got very simple circumstances and you don't have a lot of concerns about anything or wishes about anything, there's no special, unique, interesting things that need to be planned around for your family, and you're not interested in asset protection or tax planning or any of the other good things you can benefit from, it can be okay for certain families. But at the end of the day, it's important to remember that what LegalZoom is, and the tools that are like LegalZoom, what they are is essentially a will generator or a trust generator. You fill in your information and they give you back a document that they spit out. They say it's reviewed by a lawyer. I don't know whether or not that's true, but when you go, but I would ask, when you go to ask questions, are you going to be able to get an answer that's tailored to your state? When something changes in your family over time, are you going to be able to go in and ask questions and say, hey, mom passed away, I need to do this. I bought a new property, I need to put it in my trust, or my circumstances changed. Is LegalZoom going to be your lifetime advisor? Are they going to be there with you and your family every step of the way? I don't know. But what I do know is that an estate planning attorney will be. They're going to be one of your trusted advisors. Maybe you've got your financial advisor, your insurance guy, your mortgage person, or and your CPA and your estate planning attorney. They're going to be there to help you through all this process. And when the time comes, somebody passes away and it comes time and there's a trust that needs to be administered, or maybe there's a will that needs to be probated, you've got somebody there, maybe the person that drafted it, ready to work with you, to work with your family, who knows your family, who knows your assets, who knows how your estate is organized, because they help you put it together. And they're there to really help you move through that process and really get rid of a lot of the headache that I talked about when I first was telling the story of my dad and my mom and my sister and I. It would have been nice to have somebody who was a professional there guiding us through that, and frankly doing a lot of the work for us. It would have been nice, but you're not going to get that with a LegalZoom or something like that, because at the end of the day, they're spitting out a document for you, and that's all they are. And I try to be, and I think most estate planning attorneys try to be more than that.
So let's say that you have, and someone comes to you and say, yeah, I think I finally need a will, right? That's something I need to do. I need to do some sort of estate plan. What are some of the big picture things that you talk about whenever you're talking to them?
Sure. Well, so I try to start, because at the end of the day, and I guess I kind of alluded to this idea when I was talking about LegalZoom. At the end of the day, people aren't coming to talk to me about documents. They're not here to say, oh, I think I need a power of attorney or a trust or a will or something like that. What they're coming to me to talk about is that they're concerned about something. They're thinking, oh, God, what happens to my kids if I pass away? Or shoot, I don't know who's going to take over management of my small business if I get sick and I become permanently disabled, and trying to figure out what am I going to do. And they're worried about these things. A lot of times people sit on this for a while. They get on an airplane and they think, oh shit, I forgot, part of my language, I didn't update our will, or I didn't change this, what if something happens? And they come to me with these fears and concerns and wishes and aspirations about what they want to happen to their family, what they want to happen to their assets, what they want to happen to the family business or the family farm, or their accounts and things like that. Who they want their kids to go to. They have all these concerns and wishes and aspirations and fears, and so I start from that perspective. I start from the emotional side of it a little bit. I'm not a super emotional guy myself, but I think it's an important aspect of really identifying what the family wants and what they need, and how to work with them to make sure that they get it. So that's how I started. I start from getting at their wishes and their fears and their concerns, and then kind of working from there, and then crafting a plan to accommodate that, to carry out those wishes, to eliminate those fears, to get them to the other side. That's the way I try to approach it.
I love it. We're on with Dan Schnurbusch. He's an estate planning lawyer in Missouri. So if you have any questions, do make sure that you post them in the comments, or send us a text. which you can do, which is 314-668-2001. You cannot call that number. You can only text that number. So if you want to text us any questions, you can. Otherwise, just post them in the comments, and we'll be able to throw them up on the screen. All right, Dan, let's get to our next question, which is, tell us the difference between a trust and a will. You sort of covered this a little bit before, but what are the differences? And then why would someone need a trust as opposed to just a will?
So at the end of the day, and people are a lot more familiar with wills, and I understand that. I was too before I went to school and then ended up in the practice. At the end of the day, they're both two ways of doing the same thing. They're writing instructions about what you want to happen to your stuff. And wills and the main difference is that a will has no function at all unless it is probated, unless it is taken to court, entered into the court record, and litigated in essence. A trust is a private contract. It's a contract between a grantor, the person who creates the trust, sometimes called a trust maker or a settlor, on the one hand, and the trustee on the other hand. This is the person who stewards assets for the benefit of a beneficiary. In most cases, if you're creating, we'll call it a typical revocable living trust during your lifetime, you're the grantor. You're also the trustee, and you're also the beneficiary. So you are looking over your own assets for your own benefit, and you're essentially in a contractual relationship with yourself. But the differences start to kick in when you get sick or when you pass away. With a trust, for example, you can designate individuals to take over. If you get sick and I say I'm permanently disabled and I can't take care of myself anymore, you can designate people to take over and say, hey, look, here's what's in my trust. You're the trustee now. You're my successor trustee is what it's called. You can go talk to my bank. You can go work on my house or do whatever it is. You become me for my financial purposes, subject to whatever the restrictions are in the document. Again, we're kind of writing private law here. We're writing the instructions about what you want to happen. So you get a tremendous amount of flexibility when you're working with a trust. Wills are in Missouri one of the only ways to designate guardians for your kids, which is why you'll even if you have a trust, you'll tend to have a will as a backup. Say you forget to put something into your trust. A big part of the important pieces, or one of the important things about trust, is you have to remember it's a bucket. You have to remember to put stuff in the bucket, and anything that's not in the bucket still has to go through probate. So what we try to do through life is get stuff into the bucket, and if anything gets left out, there's always a backup will to kind of deal with that. But trusts, there's a world of difference, because once you get into trusts, you can start getting into things like incapacity planning. You can start getting into special needs planning. So if you have a kid who has some type of special needs and they're on government assistance, for example, maybe they inherit their assets in a way that is not includable in their estate for purposes of determining public benefits or for purposes of determining tax. You can do a lot of tax planning for both gift and estate taxes, as well as income taxes that you can effectuate through trust vehicles. That is really it's difficult or awkward, or it's sometimes not possible to do with just a will by itself. And once you start talking about trust, you can start getting into questions about asset protection, because really the idea is that you've created a legal entity, a legal fiction in a way. It's not technically an entity, it's a contractual relationship, but you can keep assets outside of a person's estate that can have benefits for bankruptcy purposes, avoiding those inclusion in bankruptcy or spouses and so on. So a trust is where you start getting into more of the advanced benefits. But the main thing that a lot of people think of is, if there's one thing I want you to take away, is that if you have a trust, you don't have to go to probate. All those assets are held by the trustee, and the trustee gets to administer them without the judge being involved. So that's one of the other big advantages. Too many things to go into in one short meeting, and some of the advantages depend on the circumstances of the family. Sometimes certain advantages aren't an advantage to one family, but they might be to another one. So it's a complex process that really depends on the unique circumstances of the family. Another reason why it's good to talk to a lawyer rather than go with a LegalZoom and say, well, maybe I'll get a trust or maybe I'll get a will, without having that one-on-one coaching to really get through your estate and your family, and to really craft a design and deliver you a plan that fits with your unique needs.
So we got another question. I want to make sure I get to everybody's questions because we've got quite a few. And this is a really good one. It's from David Terry. What recommendation would you have for getting a will done for an individual who's currently in a nursing home but unable to receive visitors? No cognitive impairment. Can everything be done by video except the signature?
Interestingly, right now, through the end of the year in Missouri and in a lot of different states, you'll have to check with the state that you're in, and depends on what the applicable law is. At least the governor in Missouri, for example, has extended e-signature and e-notary requirements or availability for people due to the coronavirus circumstances. Now, and there are also legislative initiatives being passed through Missouri legislature right now to try and make this a permanent fixture. But that's one of the options right now, is doing electronic signatures. You could have nursing staff doing a FaceTime Zoom or Zoom or a FaceTime meeting with the family if they have a notary on staff who can do that. That's an option that you can do right now, as long as you follow the requirements of the governor's orders. And this is applicable in a lot of different states. Some states, it's already a part of the statutory law that you can do electronic notaries or electronic signatures. Missouri, unfortunately, in the absence of this order, when it goes away, assuming they don't change the law, we're going to go back to having to do in-person signatures. Now, all that's required, however, is that the person be in your line of sight. So as long as they're signing and the witnesses are in your line of sight, and you can see through a window, or even at a distance, as long as you can see what they're doing and you know what they're doing and they know there's no issues of incapacity, then that's going to count as a valid signature. So there's several different things you can do right now for people who are in a tight spot on that side. And I'm very hopeful that they will continue and expand the electronic signature rules in Missouri and elsewhere to kind of keep up with the times, as it were, and make sure that going forward, after this pandemic is over, that we can continue to service clients who are in this circumstance, because it's a hard spot to be in, and it's not going away anytime soon. These are issues that are perennial, and and we'll see what happens. But those are some of the options that you can do right now today.
Excellent. So I sort of flashed this one up there, but I think it's a funny one. Aren't trusts for rich people?
Now, perhaps that is the popular conception, but no. I mean, there's nothing special about a trust that is only unique to rich people. Now, there are certain types of trusts that rich people would benefit more than other people. If you're trying to engage in, for example, advanced estate tax planning or advanced gift and income tax planning. Some of those trust vehicles where you're completing gifts to the trust, for example, are designed to take advantage of the super high exemption amounts right now. Those types of trusts are meant for people who are trying to pass a lot of wealth through the tax code as it is structured now. But for most people, virtually anybody can benefit from a trust of some kind, and if only to avoid probate and designating capacity decision makers. If you have even more modest amounts of wealth, a lot of ordinary Americans might have a decent sized life insurance policy. If you buy them when you're young and you're working with a reliable life insurance agent, you might be able to get several $100,000 or $1 million for $20-$30 a month. So if you're in that position, and that's another thing that I work with clients on, is making sure that you're talking to your advisor and making sure that you've got enough life insurance to take care of your family if something happens. And that's a decent amount of money. And trusts can help administer those assets and keep them protected from creditors, keep those assets protected from divorcing spouses, keep them out of the probate system, keep them out of the hands of minors or individuals with special needs, irresponsible beneficiaries, all kinds of different ways to benefit from those tools that are beneficial for everybody, that have nothing to do with how much money you have. Because nobody wants to end up in the public probate process Nobody wants to take 6 to 12 months to tie up your family's estate. And these tools can be used at a modest cost to deal with these, to generate an advantage for people all along the income spectrum.
Good answer. I want to make sure we've got more questions. I want to make sure we only have a few minutes left, so I want to make sure I get them in. So if anybody else has any questions, get them in now. Post them in the comments, and so we can get to them if we can. This one is from Jeff. He wants to know, hi, Tyson, does Dan do division of assets work when appropriate? I don't know what that means, so maybe you do.
It depends.
What does that even mean?
So division of assets, it can become relevant. It's often most relevant in cases where you have married couples or where you have with community property assets or other assets that need to be divided for a lot of times for tax and equalization of the estate purposes. So if you're putting assets into a trust, for example, it can be important to do a division. So a lot of times the way that I work those is I will, if they're not significant tax issues, a lot of times that will end up worked into the trust documents or into the estate planning documents that we're working on, especially if it's jointly owned marital property. It's often not that complicated to do. But if we're working on more complicated estates with more sizable asset values, I will tend to bring in outside professional CPAs are especially helpful in this area to make sure that we're structuring things in a way that optimize for tax considerations, for division considerations, and things like that. So that's kind of how I tend to approach that issue. I don't know if that answers your question, but yeah.
Well, it answers my question because I don't know what it means. So, well, I do now that you've answered it. I did know what it meant. Next question is, this may be a tough one, but it's from Amelia. What things should clients consider when thinking about who gets minor kids in case of death?
You want to think about, who knows your children? Who do you trust to take care of them? Who's responsible, both with their personal affairs, or who is likely to be at the time that your children may need guidance. I often advise people to, if they have parents, a lot of people want to name their parents as guardians, for example. I tend to be a little more hesitant on that just due to the age difference. When your kids are turning 10, your parents might be in their 60s or 70s, depending on how the age brackets line up. And it can be a lot to keep up with a young kid when you might be starting to advance in age. So I would just advise them to kind of take stock of who knows your kids and who cares about your kids and talk with them. If you have a few candidates who you think, maybe it's your sister, maybe it's your brother, maybe it's your best friend who also has kids or something like that, talk with those people and see what their thoughts are. Because if something does happen, they need to be aware, they need to be going into that knowingly that they are undertaking that responsibility. If you have concerns about somebody, maybe I don't fully trust this person's, maybe they're a little bit irresponsible, maybe they party too much or something like that. If you have concerns about somebody who you're thinking about working with or designating for this role, raise that to them, talk about those things with them and say, if something happens, are you going to be ready to take on this responsibility? And for example, if you, one of the things I mentioned earlier is if you're leaving assets behind for this person, you can always split responsibility. So maybe you have one person looking out for the children and taking care of their physical person, but maybe you have somebody else entirely taking care of the financial responsibilities. And dividing responsibility like that can help. It can help minimize the need to find like the perfect person who can do it all. So those are some of the things that I would advise thinking about, and just really being sure to work with the people who you are considering occupying this role, and airing out any concerns and getting that all out ahead of time before putting it down in writing.
Great advice. All right, let's get to the next question. This is just a sort of a procedural question. who are the ideal witnesses for a will signature? Can it be anyone?
In Missouri, at least, and I think it's this way in most states, it can be anybody who is otherwise competent to be a witness. So ideally, you would want these to be people who are adults, who are competent and capable and have all their mental faculties are there. In most cases, you will want these people to not be interested in the will or the trust, in that you don't want them to be somebody who takes under it or who has rights to any assets under the will. Because under most states' law, Missouri included, if an interested witness observes the signing of a will, you have to get another witness. And if you don't get another witness, they might be disqualified from their interest to the extent that any of their interest is beyond what they would normally get in an ordinary division. So it tends to be good to get people who you're going to be able to keep up with over the years. You're going to know who they are and where they are in the event that the will needs to be probated, that you're going to be able to track those witnesses down. So that's a consideration to keep in mind as well. So those are some of the things I would advise thinking about when selecting witnesses.
Very good. And this question is, I think this is a funny one. Tracy, one of the attorneys at our firm, she says, what is an effective way of cutting someone out of a will? Devin, you should watch out. Devin is her husband.
So it depends who you're trying to cut out. If it is your spouse, for example, and they're your current spouse, it's a tricky thing to do. They are entitled to elect against the will. So if you try to cut out your spouse, for example, that is a current spouse and not a former spouse, they can elect against the will, and they're entitled to take a significant percentage of the estate. Now, there are lots of exceptions to this, so that those rules don't apply if you have assets passing through beneficiary designation or a transfer on death designation or other things like that. But the way that if you don't have concerns like that, or you don't have issues of an heir that you forgot about or something like that, because sometimes called a pre-termitted heir, we don't need to get into that. But one of the ways that you can do it is leaving the person a token amount. So maybe you've got a child who is no longer, who doesn't want to talk to you anymore, for example, and the relationship went bad, and you don't want them to take under your will. One of the ways that you can do that is say, I'm going to leave you, a few $1,000s, and include a no contest provision in your will. And basically what those do is that they act to disinherit anybody who tries to challenge the will. So I tend to advise people that if you're going to disinherit somebody, don't make it like $5 or $10, because then they really have nothing to lose if they decide to challenge the will. If you leave a few thousand, maybe they say, I see this provision that says I'm going to be disinherited. If I don't get the third of the estate that I wanted, but at least I get $3,000 or $4,000 or whatever it is. And then they go away disappointed, but at least they're not going to end up pushing you into court, and you're not going to pushing the rest of your family into court and into contentious litigation. So those are some of the things you can think about, giving them a little nugget, and otherwise expressly including in there. I'm only giving this amount to this person because of XYZ, and really spelling it out. Because the more that you spell out your intentions and your wishes and why you're doing it that way, the less likely it is that a contest would be successful.
Fantastic. Great advice. So Dan, thank you so much for joining us. If anybody else has any questions, they can reach Dan at 314-246-0578. His email is dan@schnurbuschlaw.com. Dan, anything else you want the people to know?
Well, let me think about it. The only other thing would be that through the end of November, I am running a Black Friday special. So if you want to come in and get your estate plan done, I'm running a Black Friday special where if you come in before the end of November and you decide to sign up, I'll knock 20% off whatever the ordinary sticker price would be. And that's just a little thing that I'm doing right now. So a shameless plug. Black Friday special. So
That's
come on down.
fantastic. Yeah, and if you're in the state of Missouri, I mean, Jesus, you may be in the St. Louis area, but I mean, someone in the Boot Heel can hire you. So
Sure.
fantastic. So yeah, so give Dan a call if you do this, right? I don't get anything out of this. This is just for him, but that's fantastic. That 20% is a good deal. So that's awesome, but pretty cool. All right, Dan, thanks so much for joining me. Thanks for everybody for watching and submitting your questions. This is the first time we were using this, so it's pretty cool. But thanks so much, and have a great day.
All right. Thank you, Tyson. Appreciate it.